Number 179, People versus Jorgensen. Counsel, would you like any rebuttal time?
Maybe 2 minutes, Your Honor.
2 minutes, you're on. Go ahead.
Thank you, Your Honor. Good afternoon. May it please the Court. My name is Richard E. Michel. I represent the defendant, Jennifer Jorgensen. On this case,
Counsel, is the crime that the defendant is accused of in relation to the fetus, is that a possible crime in New York? Has there ever been anyone held?
But our introduction, Your Honor, to this argument is this case in the state of New York is unprecedented.
Is it a crime impossible to commit?
It is impossible to commit this
Why?
crime.
Tell us.
Because at the time that the acts that are alleged to be reckless were engaged in by my client, the purported victim was not in existence at the time in a legal sense.
Didn't we have a case where someone recklessly shot a pregnant woman and killed the fetus? And
Yes, Your Honor.
Bit of that?
And the basis for that case is that it was a third party who did it and not the
You could have this crime if it was a third party?
Yes.
If
Absolutely. And the reason
the baby have to be born alive to have that?
the baby ultimately is born alive and then dies.
So under that circumstance with a third party, there is such a crime?
Yes, there is, but not when the natural mother.
Why not in this case?
Because at the moment.
Common law, or what is it? Derogation of common law?
That is
what's
correct.
Your
Because under the born alive rule, at the moment that the third party engages in the conduct, Your Honors, at that very moment, whether it's directed at the unborn baby or at the mother, it's a crime. The defendant pulls out a gun and shoots the mother. The mother is injured. The baby is born later and dies, but is born alive. A crime has been committed.
Did that happen? Pardon me. Did that happen in the case of the shooting?
Yes.
The baby was born alive?
The baby, in the Hall case, the baby was born alive, Your Honor, and then subsequently died from the injuries, the gunshot.
Is the difference here, counsel, that the mother is doing something to her own body?
Correct.
And that's not a crime? Is that what you're saying?
She, with very limited exceptions here, Your Honor, under Article 125, cannot commit a reckless crime against herself, at least none that I'm aware of that's defined in the penal law. That being the case, there is no derivative right that the fetus has until such time as the baby is born and is born alive. If there were any acts engaged in by Ms. Jorgensen after the baby was born, I wouldn't be standing here arguing this to Your Honors.
Well, the baby was injured, it was born alive, and it died 7 days later.
Yeah, but when the baby was injured, Your Honor, and this is critical, the baby was not born. So the mother,
so let me understand the distinction. The mother, if she committed the act to the baby after the baby was born, different case?
Absolutely.
So what you're saying, whatever she did beforehand, drugs, reckless driving, whatever you might hang it on, it doesn't matter. You can't commit that crime.
You can't commit.
You can't be prosecuted for that crime.
You can be
but you can't
You can't be convicted of manslaughter in the second degree, Your Honor, because at the time Ms. Jorgensen allegedly drove that car recklessly. This baby was not a person within the meaning of the law.
So if there had been no C-section.
Correct.
And the baby then dies in utero, she's not liable for any criminal act.
No. The only crime that she would be liable for.
Because we got the C-section here and the baby was removed and survived for a period of time.
Right. So
let me ask you this.
Yes, Your Honor.
This argument, I find it to be a difficult argument, a challenging argument, I think. But is this preserved?
Your Honor, it was not. No, it was not raised. It was not raised in the appellate. We're raising it as a jurisdictional defect.
All right. Then let me go to because there are some other points here. You know, as I went through, two things that leap out at me. First off, the argument that you make that the prescription drug history that came in I think that needs to be addressed, because that was properly preserved and properly objected to. And then the prosecutorial misconduct argument that you made in relationship to the probation statements, that was also specifically asked. And it doesn't require us to deal with the thorny question of the personhood of the child that eventually died.
That certainly the case can be resolved on that basis. But, Your Honor, if you resolve it on that basis and you send it back for another trial, where are we then? And if I may just address then, for Your Honor's satisfaction, why this case doesn't fall within the preservation Hawkins rule and comes within the jurisdictional rule, I'll just take 30 seconds of your time for that.
Go ahead.
The reason for it is simple, Your Honor. If you believed all of everything that the prosecutor offered in this case, no question about it, everything that's to be believed, the argument remains the same. There's nothing that an objection can cure at this point.
Well, I don't know. The indictment at 125-15-1 says recklessly caused death of the child who was in utero at the time, and nobody objected to that, and she went to trial on that, and she got convicted of that. Now, no court has had an opportunity to address that except now us, and you're going to ask us to make certain factual determinations, I suppose.
There are no factual determinations, Your Honor. The only issue in this case is whether or not the baby that was born alive was a victim.
Right.
There are no factual issues in that construct.
Sure, but I mean, isn't it conceivable that a court, either an E.C. Brias court or an intermediate appellate court, may say, we think that a child who is within 3 weeks of birth is in fact a child, and it is manslaughter sentence?
Then that would be in violation of the statute.
What statute?
125, Article 125.
Not what this says.
Well, Judge, Your Honor, with all due respect, there's the definition in 125.051, which says that a person is a human being who was born and is alive.
Okay.
And counsel, let me understand one thing. Let's clarify this. So in a state that says by statute, and there are a few in the country, that the fetus is a person, then you could have a crime. It is possible to commit a crime in that state if that's the definition of the fetus, right or wrong?
You're absolutely correct, Your Honor. And what's interesting is that the district attorney, they cite this proposed legislation where it's clear from the proposed legislation that what the legislation is attempting to do is modify the definition of person so as to include a viable fetus. Viability is not an issue here.
Let me ask you this. Is it endangering the welfare of a child if you abuse yourself such that a child is born defective or?
I respectfully submit to this Court that reckless endangerment or endangering the welfare of.
Stick with me. I'm saying a child is born a drug addicted.
Right.
Has the mother endangered the welfare of a child by taking drugs during pregnancy?
No.
That's not a crime in this state?
That is not a crime in this case.
No, in this state.
In this state, it is not a crime.
Okay, counsel, thank you. You have your rebuttal. Let's hear from your adversary.
Good afternoon, Your Honors. I'm Assistant District Attorney Carla Leto.
Counsel, where's the crime? Under our statutory framework.
Under Penal Law 125, we're recognizing the victim of a homicide can be a fetus of at least 24 weeks gestation. Under 125.05, we're recognizing that a person who is a victim must be born alive.
Has that happened a lot here? Have we seen a lot of these cases?
No, Your Honor, this is a case of first impression.
Okay.
With regard to the homicidal acts being perpetrated by the mother.
Isn't it sort of an incongruous result that if this defendant had intentionally committed self-abortion, for example, she could be convicted of a misdemeanor? However, now we're talking about reckless conduct, and it turns into a felony.
Under the self-abortion statute, the intent is to miscarry. And
all I'm saying is in either event, you don't end up with a live person. one act is intentional, the other is reckless. Wouldn't we treat intentional more seriously than we would reckless?
But, Your Honors, the self-abortion statute, there is never a child born.
Well, in this case, you're saying that her error was in consenting to a C-section.
I'm not saying that's an error, Your Honor.
Well, suppose she hadn't.
If she had not consented to a C-section, there would not be any crime which we could have prosecuted her under.
She had been even more reckless and the baby had just not been born alive.
I'm sorry, Your Honor?
He'd been even more reckless, and the child would not have been viable outside of the uterus.
So you're saying
Then again, there would not be a crime.
In those examples under your rule.
Can I ask you
Yes.
about at one point you say that this is a compromise verdict because the jury wanted to show compassion or something?
Yes, we believe that the verdict was a result of jury nullification. Which is
Could they have said, well, we think she's guilty of manslaughter with respect to the passenger in the other car, but not with respect to the driver in the other car, and therefore convict her with respect to Mr. Kelly and not Mrs. Kelly? Would that be a verdict that we could let stand?
No, Your Honor.
Well, aren't you picking and choosing then?
No, Your Honor, we're not. Because the reckless acts which we had, the base reckless acts, which were speeding, running a red light, driving on the wrong side of the road, failing to brake as she was headed toward another car.
Cell phone, drugs.
Yes.
Acquitted of the drugs, though.
She was acquitted of the drugs, Your Honor. However, she was acquitted of being impaired by the combination of the alcohol and the clonazepam. The jury could have found that she had one or the other in her system, which could have affected her.
How if she's acquitted, and this is the fair trial argument, on the clonazepam and the alcohol level she had was .06, which doesn't even mandate an impaired. The clonazepam was so low that normally it would be reported as negative. I believe that's what the experts said. But it has a long half-life, so it was taken somewhere between 20 to 60 hours beforehand. So in that context, where the evidence is so weak, how can you possibly argue that evidence should have been admissible, number one, and that if it is admitted, that it's fatal error, not harmless error?
Your Honor, that evidence went directly to the synergistic effect that the alcohol and the clonazepam had upon each other. And when combined, it enhanced the side effects.
Let me just stop you for 1 second and I'll let you answer the question. I don't mean to interrupt you, but the jury made a determination that there wasn't an intox here. Am I wrong about that?
That it wasn't impaired by the combination effect of the alcohol and the clonazepam. Yes.
All right. So then this entire case then is premised on the fact that she got in an accident and didn't have her seatbelt on? Because if she's not an impaired, what are we left with?
We are left with the speeding, driving on the wrong side of the road, failing to brake.
Speeding. Right,
with, getting back to, Your Honor, but with regard to the infant, we have the added factor of failing to wear her seatbelt.
Let's talk about added factor, because the DA argued any one of them is sufficient to convict. Is that the appropriate standard?
No, it's not, Your Honor, and the Court gave curative instruction to the jury that the Court alone would instruct them as to the standard, and they were to disregard what she said with regard to the law.
Counsel, could I go back to something that Judge Fay asked your adversary, which is about this argument concerning the fetus? Is that preserved below? And what's your position?
No, Your Honor, it was not preserved below. The defense counsel only raised an issue with regard to endangering the welfare of a child and whether or not the baby in this case could be a victim under that statute.
Does it matter if it's impossible to commit the crime?
Your Honor.
Does it matter if it's impossible to commit the crime?
Your Honor, no. We have
It doesn't matter.
I'm sorry.
So then Good. What's your answer? I'm sorry.
I'm sorry, Your Honor. It is possible to commit this crime because
I know that's your argument. I'm saying if it's impossible to commit the crime, does it matter whether it was preserved?
No, Your Honor, it doesn't.
Okay.
Can we consider your adversary's other argument that we don't have jurisdiction?
Yes, Your Honor, you may.
Okay. Thanks, Counsel.
Thank you, Your Honors.
Counsel Urbano?
I must confess, Your Honor, a great deal of terrain was covered here. I don't know where to begin, but I want to make it clear, because the prosecutor in her brief refers to viability several times. The issue here is not viability. They get the viability issue from the 24 weeks in what is defined as homicide, what constitutes a homicide. And
You agree that here that was met?
pardon?
That you agree that here that
Oh,
was met?
absolutely. But
Right?
I'm saying most respectfully that has nothing to do with the case, because the argument, Your Honor, would be very much the same. She would be making the very same argument if it were 22 weeks, if it were 15 weeks, and the baby survived the reckless conduct supposedly engaged in by my client sitting back there. The argument would be the same, that if the baby is born alive and survives and then dies, my client is subject to prosecution. It has nothing to do with viability.
Listen to you. I mean, you're making this argument, and it has a lot of substance to it, but it comes out, I mean, you've got all these other arguments, and you're not making any of them. The DA, I thought in her summation was a little over the top.
Right.
I didn't know, but I was surprised her doctor testified. I didn't know where the physician-patient privilege got waived, and it took 13 months for them to bring the misdemeanors, which then all got thrown out.
Correct.
And yet the evidence came in one shape or form with respect to the manslaughter, and you've moved all of those off, and you just want to talk about an issue of first impression here. And shouldn't we be focused on some of the other ones just in the event that we don't want to address the issue you're raising?
I agree, and that's why I prefaced my remarks, because I said that an awful lot of terrain was covered in the questioning of the district attorney. But
Particularly because it's such a profound issue, I think of almost national importance, and it's not been properly briefed or addressed by the courts below, and you have legitimate fair trial arguments. I don't know if they're winning arguments, but they're certainly legitimate arguments.
well, certainly the admission of a volume of evidence pertaining to 7 months of prescription drug history, when the court specifically at the very beginning limited what this evidence was going to be admitted for. It was going to be admitted because of the experience from the first trial about the synergistic effects of combination of drugs and alcohol, and it was going to be and tolerance and cross tolerance, which was offered by the district attorney, by the people. That was part of their main case. The second thing came.
Finish off, Counsel. The time is
What the purposes for which it was admitted, which was never explained to the jury. Never explained to the jury. On summation, the prosecutor uses every conceivable, every possible use for to discuss with the jury that Ms. Jorgensen is self-medicated, is drug addicted, is using these drugs, is a bad mother, and at the very end, which was objected to, she takes Petracco's testimony, the OBGYN, which was objected to by defense counsel at page 542, and says, poor baby blank. She was born with an APGAR score of 1. She was put on life support. Was this due to prematurity or due to the drugs, which we know affects the outcome of the birth? We will never know, she says. That, I submit to the court, not only changed the theory of the prosecution as to what the cause of death was, but was a tacit admission by the prosecutor that she couldn't prove cause of death.
Thank you. Thank you both. Appreciate it.